The slides.
The slides are visible.
Thanks, Anthony. Okay, we're going to go ahead and get started. Again, thank you for joining us today. This is basic training for beginners or for new FOIA officers in the DC Freedom of Information Act. My name is Brandon Lewis, and I am the trial attorney here at the Office of Open Government. And we are going to go over the basics of DC FOIA today. There'll be a good number of slides, but hopefully we'll get through them fairly easily. And there are a few sections that feature questions. So I will invite you at that time to put your answers into the chat. Additionally, as we go along, if you have any questions, please feel free to put them into the chat, and my colleague will try and answer those for you. And if we don't get to them in the chat, then hopefully we'll have enough time at the end for any questions. Additionally, we usually get this question a lot. The training materials will be available on our website. And also on our website, you can find previous trainings that we've done in case you ever need a refresher in any of the information that's being provided today. Okay, the DC Freedom of Information Act is contained in DC Official Code sections 2-531 through 2-540. And here you'll see essentially a breakdown of the different sections that and what is covered in each section. These are some additional sources for interpreting DC FOIA and for processing requests. And again, if you access this training at a later time from our website, these links should be active to take you to some of these other sources, such as DCMR and also advisory opinions from the Mayor's Office of Legal Counsel. And then additionally at the bottom, we've listed some case law that pertains to FOIA. There's some additional sources of information for both DC FOIA and FOIA at the federal level. Okay, so what are records under DC FOIA? Records that must be available to the public, we're going to start with proactive disclosure. So these are the records that should be available to the public without a FOIA request. And they include employee salary, title, employment dates, contract expenditures, budgets, manuals, policies, rules, opinions, orders, as well as meeting minutes of open proceedings of public bodies. That last one is an interesting one. Our office also handles OMA enforcement. And we've had a few situations in which members of the public were trying to obtain recordings of public body meetings, and some well-intentioned folks at the public bodies thought that that needed to be in a FOIA request, and it does not. So that is among the things that should be readily available to the public. Public records include all books, papers, maps, photographs, cards, tapes, recordings, vote data, including ballot definition material, raw data, and ballot images, or other documentary materials, regardless of physical form or characteristics. that are prepared, owned, used, and in the possession of or retained by a public body. Public records include information stored in an electronic format. I've cited to DC code below here. So start with our first scenario. If a colleague says to you, I'll text you that information, is that text a public record? As an example, Nick tells a fellow employee, I'm looking for my government-issued cell phone and will text those government statistics the office has compiled to your government cell phone. So are text messages public records? And then got a couple of options here. A, no, text messages are not public records. B, no, if it's between government employees, it's private. C, it is up to each agency director to decide if they want agency text messages to be records. Or D, yes, they meet the definition of a public record. I'll give folks a moment if they want to read, maybe put their answer in the chat. Good. I see most folks selecting D, and that is correct. Yes, they meet the definition of a public record. In a March 16, 2022 advisory opinion, the Director of Open Government opined that a district government employee that conducts government business via a text or similar electronic method under the scope of employment creates a public record under DC FOIA. What if we store agency records on a personal server and email account at the agency director's home or off-site? Choices are A, they are still agency records subject to FOIA. B, they are not maintained by the government and therefore not public records. Or C, they are not government records and lose their character once on the private server or stored off-site. Give you a moment for folks who may want to answer that in the chat. And if you picked A, you are correct. They are public records subject to FOIA. Now we're going to come back to the definition of a public record. The term public record applies where the content is prepared or used by a public body. The means of storage is immaterial. Government personnel cannot evade DC FOIA simply by preparing records on media that they happen to own. And here's a little bit of case law. Where an agency refused to provide requested records on the basis that the agency had maintained them on a private email account in his name at a site other than the government email site which the agency had searched, the requester's FOIA compliance action was erroneously dismissed because an agency could not shield its records under FOIA by the expedient of storing them in a private email account controlled by the agency head. If the agency had controlled what would otherwise be an agency record, then it was still an agency record and still must be searched or produced. It was not apparent that the domain where an email account was maintained controlled the emails therein to the exclusion of the user. And the agency's claim was inconsistent with the purpose of FOIA, which was to serve the citizens' right to be informed about their government. And so the takeaway from this is essentially, if it pertains to a government record, it doesn't matter if you put it on your personal device, it is still a government record. DC Official Code 2-532A, any person has a right to inspect and at his or her discretion to copy any public record of a public body, except as expressly provided by the FOIA exemptions. Okay, so who is any person that may submit a DC FOIA request? Does any person refer to any District of Columbia resident, any natural person, or C, a person, natural or corporate, regardless of their residency or location? Good, I saw a lot of C responses, and C is the correct answer. While, for instance, in Virginia, you must be a Virginia resident to submit a FOIA request for Virginia's records. Under DC FOIA, any person includes non-residents and corporate entities. Does any person include anonymous requesters? And then we've got this example of an anonymous FOIA request. No way to tell who I am, ha ha ha, at gmail.com has submitted a FOIA request that says, Dear FOIA officer, I am requesting copies of all records you have that mention Ray's Boom Boom Room nightclub. I am willing to pay up to $100 for these records. The records may be sent to me or any correspondence regarding this request at my email address, no way to tell who I am, ha ha ha, at Gmail. Thank you and have a wonderful day. And so in this scenario, what would you do? The options are A, email the requester and ask for their name, telephone number, and mailing address. B, delete it from your inbox as trash. C, send it to your subordinate to handle if you are a supervisor, or to your supervisor if you are a subordinate and request that they handle it. Or D, process the request with the email address that you have. And the answer here is D. Okay, 1 DCMR section 402.3 does not require that the requester identify him or herself. In relevant part, the provision states that a request shall include a daytime phone number, email address, or mailing address for the requester. And the exceptions to this are when an individual requests records pertaining to himself or herself, and therefore possesses the ability to waive his or her own privacy interests, or when a requester seeks a fee waiver based on affiliation with educational, news media, or other entities. Here's another scenario. We work with private contractors. Do any records include private contractors' records? I'll give you a couple of options. The choices are A, DC FOIA doesn't reach these records. B, yes, if the contractors are performing a government function. C, DC FOIA doesn't address this issue. Or D, yes, but only if the contractors don't mind sharing the records. And here B is the correct response. A public body shall make available for inspection and copying any record produced or collected pursuant to a contract with a private contractor to perform a public function, and the public body with programmatic responsibility for the contractor shall be responsible for making such records available to the same extent as if the records were maintained by the public body itself. Now we're going to talk about responding to a FOIA request. For records other than body-worn camera recordings, an agency must respond within 15 business days. This is in DC Official Code 2-532C1. For body-worn camera recordings, an agency must respond within 25 business days. In unusual circumstances, the agency may invoke an additional 10-day extension by written notice to the requester, setting forth the reasons for the extension and the expected date for the determination. That's in DC Official Code 2-532D1. And DC Official Code 2-532E provides that failure to timely respond to a FOIA request is deemed a denial of the request. So what are unusual circumstances? The FOIA officer believes the request for the review of 20 emails, given other non-FOIA responsibilities and the FOIA assistant being on leave, to be unusual circumstances and invokes the extension. A, sounds unusual and I think it's all right. B, DC FOIA states what are unusual circumstances. Or C, DC FOIA does not provide guidance on the issue. This is decided by the agency guidelines. Here, B is correct. DC FOIA lists the conditions for unusual circumstances. DC Official Code 2-532 D2 defines unusual circumstances as the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded in a single request, the need for consultation, which shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request, or among two or more components of a public body having substantial subject matter interest therein, or for body-worn camera recordings, the inability to procure a vendor that is able to perform the redactions within the 25-day time provided under subsection C2 of this section. Okay. Communication may result in cooperation. In the 2016 decision, the court said that a FOIA requester and the district entity receiving a request are not or should not be in an inherently adversarial relationship. Litigation is authorized as an enforcement mechanism, but it is not meant to be the inevitable path. Each case has presented its own discrete issues, but the constant is an apparent inability or unwillingness by both parties to communicate effectively to achieve the objectives animating FOIA. Both parties seem to have forgotten what FOIA is all about. And this comes from Fraternal Order of Police v. District of Columbia. And the point of that being that communicating with the requester can benefit both parties. If you can explain, one, if you can speak to the requester and really hone in on what it is that they're trying to get, you can better provide them with the information that they're seeking, and also as well it provides you with the opportunity to, explain to the requester, especially in situations where they may have requested a large amount of documents, the process that you'll need to do to get them those records. I need it yesterday. Request to expedite processing FOIA request. You receive a DC FOIA request seeking expedited processing. The request states and demonstrates a compelling need as per 5 USC section 552A 6 E I and 3. This is from Federal FOIA's expedited review provision. You may A, ignore the request completely, B, process the request under normal FOIA timeframes and explain there is no expedited review under district law, or C, expedite the request and respond to the requester prior to the 15 calendar day period and any lawful extension. Give you guys a moment to take a guess at this one. B is the correct response. Process the request under normal FOIA timeframes and explain there is no expedited review under district law. So while there is a provision to expedite federal FOIA requests, there's no such provision in DC FOIA. Okay, and then next, also please excuse the graphic, it's a little outdated. It says FOIA Express and the district uses GovQA now. However, the principle is still the same. An agency website reads, please use the portal for submitting all FOIA requests. It's the quickest method to get a response. The FOIA portal may be the simplest and best means to submit and process FOIA requests, but may an agency require the public to submit through the portal? A, yes, because FOIA's public policy is to minimize cost and time delays to persons requesting information. B, Yes, because of the ease of use of the portal, or C, no, an agency may not restrict the method a requester uses to submit a FOIA request. And the correct answer here is C. An agency may not restrict the method a requester uses to submit a FOIA request. 1 DCMR section 402.1 says a request for a record of an agency may be made orally. DCMR goes on to say requests may be mailed, faxed, or emailed. Email, faxes, and mail requests must state FOIA request on the subject line or envelope. And then there's one caveat here for submissions to OAG from 1 DCMR section 1302.1. Unless agreed to in advance and confirmed in writing by the Office's Freedom of Information Act officer or the Chief Deputy Attorney General in the absence of a designated FOIA officer, a request for a record shall be made in writing. But again, that applies only to submissions to OAG. Now we're going to discuss exemptions in DC FOIA, which are contained in DC Official Code Section 2-534. And I'm going to list them. I won't read all of them here, but for instance, trade secrets, commercial or financial information, Exemption 2, personal privacy, information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. Body-worn camera recordings recorded by the Metropolitan Police Department that are inside of a personal residence or related to an incident involving domestic violence, stalking, or sexual assault as defined by DC Code. Investigatory records compiled for law enforcement purposes, including records of counsel investigations and investigations conducted by the Office of Police Complaints, but only to the extent that the production of such records would interfere with enforcement proceedings, counsel investigations, or Office of Police Complaints ongoing investigations, or deprive a person of a right to a fair trial or an impartial adjudication, or constitute unwarranted invasion of personal privacy. Exemption 4, common law discovery privileges. Attorney work product applies to documents prepared by or for an attorney in anticipation of litigation, no matter the status or stage of the litigation. Attorney-client privilege protects confidential communications between the agency and their attorney. And deliberative process, the method through which an agency creates policies, opinions, rules, and regulations. To qualify for this exemption, the record must be both pre-decisional and deliberative. Pre-decisional documents are those that are generated before the adoption of an agency policy, and a document is deliberative if it is a part of the agency give and take, a process by which the decision itself is made. Exemptions continued. As you can see, there's many of them. Future exam questions, information that is specifically exempted by other statutes, national security matters, antitrust investigations, arson investigations, emergency response plans, whistleblowers, homeland security records, teacher evaluations, certain information of private vehicles for hire. Let's see. And consult the rest as well. Okay. So a FOIA requester seems to want this or maybe that. It's unclear to me, so I should A, contact the requester and seek clarity. B, put the request on hold until the requester inquires about the request. Or C, put the request on hold, immediately contact the requester and seek clarity, and inform the requester of the status and document attempts to reach the requester. And here the correct answer is C. Put the request on hold, immediately contact the requester and seek clarity, inform the requester of the status, and document attempts to reach the requester. And then some additional information on this point. A request shall reasonably describe the desired records. Where possible, specific information regarding names, places, events, subjects, dates, files, titles, file designation, or other identifying information shall be supplied. Where the information supplied by the requester is not sufficient to permit the identification and location of the record by the agency without an unreasonable amount of effort, the requester shall be contacted and asked to supplement the request with the necessary information. Every reasonable effort shall be made by the agency to assist in the identification and location of requested records. If requested record cannot be located from the information supplied, the requester shall be so notified. And when the Freedom of Information Officer, pursuant to Section 402.5 of DCMR, contacts the requester for additional information, then the request is deemed received when the FOIA officer receives the additional information. Another scenario. In addition to other information, a responsive record to a FOIA request contains a citizen's name, home address, and telephone number. The FOIA officer denies the request and withholds the entire record. Is this the correct decision? Then the options are A, yes, to protect the citizen's personal privacy. B, no, it became public once turned over to the district. C, redact the personal information, then release. D, redact the name and release. And the correct answer here is C, the redaction rule from DC Official Code 2-534B, which allows for the release of the records by concealing the exempt portions from public view. The justification for the deletion must be explained fully in writing, and the extent of the deletion must be indicated on the portion of the records which is made available or published, unless including that indication would harm an interest protected by an exemption under which the deletion is made. If technically feasible, the extent of the deletion and the specific exemption shall be indicated at the place in the record where the deletion was made. Okay, what if a requester says, I want the information in an Excel spreadsheet? The agency does not keep requested information in spreadsheet form. So should the FOIA officer A, create a spreadsheet for the requester, B, supply records in the form the agency maintains, or C, send records to a third-party vendor that can timely create the spreadsheet? You guys responded quickly to that, and you are correct. B is the correct response. FOIA does not require an agency to create documents or opinions in response to an individual's request for information or to obtain records from another agency, nor does an agency have to respond to questions disguised as a FOIA request. Gone up in smoke. On Thursday, a few records contained solely on the director's external hard drive were destroyed by a small office fire, causing the hard drive to explode. The next day, the FOIA officer receives a FOIA submission requesting copies of some of the destroyed documents. Okay. In this scenario, should you A, ask the director if he/she is able to recreate the documents, B, wait until DC Fire and EMS completes their report regarding the cause of the fire. Fire and EMS say that it will take 6 months to complete such a report. Or C, immediately notify the requester that the documents were destroyed and no longer exist. And the correct response here is C. So remember that there is no obligation under DC FOIA to create records that don't exist. If a requested record is known to have been destroyed or otherwise disposed of, then the requester should be notified of such. Now we're going to discuss FOIA fees. Public body may establish and collect fees not to exceed the actual cost of searching for, reviewing, redacting, and making copies of records. Documents may be furnished without charge or at a reduced charge where a public body determines that waiver or reduction of the fee is in the public interest, because furnishing the information can be considered as primarily benefiting the general public. That's DC Official Code 2-532B. A requester seeking a waiver or reduction of fees shall provide a statement. Oh, sorry, I think my move here. My light went out for a moment. Okay. A requester seeking a waiver or reduction of fees shall provide a statement in his or her request letter explaining how the requested records will be used to benefit the general public. Advance payment is allowed when the request will exceed $250 or the requester has previously failed to pay, and fees are payable to the general fund. Denials. Denial by a public body must contain the specific reasons for the denial, including citations to the particular exemption or exemptions under DC Official Code 2-534, relied on as an authority for the denial. The name of the public official or officials or employees responsible for the decision to deny the request, and notification to the requester of any administrative or judicial right to appeal under DC Official Code 2-537. Regards to appeals, a requester who receives a letter of denial or where an agency fails to supply the record within the statutory timeframe may file an administrative appeal with the mayor's office of legal counsel or institute proceedings in DC Superior Court. Within 5 days, excluding Saturdays, Sundays, or legal holidays of receipt of an administrative FOIA appeal, the agency must file a response. An agency may request additional time to file the response to the FOIA appeal by filing a written or emailed request with a copy to the requester within 5 days, excluding Saturdays, Sundays, or legal holidays of receipt of an administrative FOIA. Failure of an agency to respond to an administrative appeal during the 5-day period or an extension granted constitutes a waiver of its right to respond to the appeal. This is a note on annual reporting requirements. On or before February 1st of each year, the mayor shall request from each public body and submit to the council a report covering the public record disclosure activities of each public body during the preceding fiscal year. The Corporation Council, which is now the Office of the Attorney General, shall submit an annual report on or before February 1st of each calendar year, which shall include for the prior fiscal year a listing of the number of cases arising under this section, the exemption involved in each case, the disposition of the case, and the costs assessed pursuant to DC Official Code 2-538C. I'm realizing I have gone at light speed to present a lot of information. We are at the end of the presentation. Here is the contact information for our office. The Office of Open Government is led by Director Nikel Allen. Again, I'm Brandon Lewis, the trial attorney here. The Chief Counsel is Louis Neal. My colleagues Joan Lelma and Anthony Skirbo are attorney advisors. Our paralegal specialist, Kimberly Brown, and our IT specialist, Kevin Brown. And here's our contact information if you need to reach us with questions. And at this time, I'd be happy to take any questions if you either want to put them in the chat or if you're able to take yourself off mute, if you want to ask them, that's fine as well. Not seeing any questions so far, but I'm happy to stick around given that we have finished in such a quick amount of time. So if you're over there still mulling over something, feel free to let us know. I'll stick around.
Hello.
Yes.
Hi. This is Allison Hughes. I'd like to know if this presentation will be available.
Yes, it will be. It will be posted to our website. We've got a section with documents and trainings. If you click on that, then it will include today's presentation as well as several others that we've given in the past.
Okay, great.
And
Thank
the
you.
link is in the chat.
All right. Thank you.
Thanks. There's no further questions. I just want to take the opportunity to thank you all again for joining us today. There will be an additional FOIA training on April 9th conducted by my colleague, Anthony Skirbo. So if you need some additional FOIA information or you know someone else who might benefit, please let them know and we'll be sending out an invite for that closer to the date.